Before we get started, we just want to thank Old Republic Surety for sponsoring this episode of Let's Get Surety, as well as NASBP virtual seminars for the 5th year in a row. For more information on Old Republic Surety, visit www.orsurety.com. Now on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. Today I have with me my co-host Mark McCallum, CEO of NASBP. Hey Mark.
Kat, great to be back with you.
Always good to have you on with me. Today we have an exciting topic. We're going to be talking about mitigating the risk of construction defect claims. And I know claims is always a hot topic that everyone wants to know more about. So to talk about that with us today, we have Joseph Young. He's a partner and board-certified construction attorney with Smith Currie, and he's located in the firm's Fort Lauderdale, Florida office. Thanks so much for being on with us, Joseph.
Thanks so much for having me. I really appreciate it.
Well, before we dive into the topic today, could you just tell us a little bit about yourself and about Smith Currie?
Sure. So I'm as you mentioned, I'm a board-certified construction lawyer. My background is in construction. I was in the construction industry first. I got a Bachelor of Science degree in construction management from the University of Cincinnati. Worked for some developers and general contractors, and then I went and got my law degree from University of Miami. And I practice 100% construction law, representing all aspects of the construction industry, from general contractors to sureties, to construction managers, trade subcontractors, suppliers, design professionals, and owners. So I see all sides of the industry, and it's all I do and what I love. So our firm, likewise, really all we do is construction law and government contracts. We're all around the country. I think we're the oldest construction law firm in the country. We were just put a little plug in. We were just awarded the Construction Law Firm of the Year by U.S. News, which is something that I'm really proud of because that's
congratulations.
Congratulations.
We stick with construction law and we're good at it. So
that's terrific. So if we're going to dive into mitigating the risks that are related to construction defect claims, I feel like we should start with talking about what would trigger those defect claims. Can you dive into that with us a little bit? What are the sources of those claims?
Sure. So construction defects come in various stages of the project. Obviously, during a construction project, you have all sorts of issues with regard to workmanship and stuff like that. But you also have ongoing risks because not every sort of construction defect or deficiency is readily noticeable when you construct the project. And presumably, if there is a problem with your workmanship that is known at the time, it's going to get fixed before you turn the project over. So a big liability that you have with regard to construction defects is ongoing exposure for latent defects. And you've got sort of various different obligations there. Construction contractors have obligations under their contract to perform the work in a certain way in accordance with a certain set of documents. Construction contractors have obligations under the law. There's building code obligations. There's other statute obligations that are imposed by the state law that you're working in. There are ongoing warranty obligations that you owe to various parties. And then there's just general concepts of what we call negligence, and that's a concept that was created by the courts that is not really founded in your contract. It's not founded in the legislature. It's just you have a general obligation not to cause harm to other people. So those are sort of the sources of liability where you see construction defect claims and things of that nature.
Hey, Joseph, you used, I think, a term of art, latent defects. So is there certain language that is associated with defects from a legal standpoint, like obvious versus ones that are not readily observable? Could you kind of say what those terms are?
Sure. So there's two different types of defects. There's what we call patent defects. Those are sort of open and obvious defects that a reasonably prudent person would have noticed, right? And then you've got the opposite of that, which is latent defects. And latent defects are deficiencies in your work that a reasonably prudent person wouldn't readily observe. And a good example of that is say you build a building and everything looks all good, and then 3 years down the road the roof starts leaking. Well, when you go and dig into why the roof was leaking, well, on year one it looked good. I mean, nothing was leaking, everything was working fine. Year two, things start to deteriorate because maybe you did your flashing incorrectly or something like that up the wall. Well, when the building ages, deficiencies in the work, what we call manifest themselves. And that's not something that is obvious. You don't know that you constructed something wrong, because presumably if you constructed something wrong and it was open and obvious, someone would tell you to go fix it and it wouldn't have been accepted. So latent defects are things that sort of manifest themselves later on, which is why you've got ongoing warranty obligations. Like you see a lot of warranty obligations that are a year, or you see, say, a roofing, a manufacturer's warranty where you've got a 20-year, no dollar limit warranty. And that's because these defects aren't always readily observable at the time, and they take time to manifest themselves. So you always have the ongoing risk of these problems coming back at you years down the road, and not just during your active construction projects.
Well, you hit on something that I want you to explicate just a little bit more. So you talked about acceptance, and that's a key concept in a construction contract. So what is the importance of acceptance vis-a-vis a patent defect versus a latent defect? Could you explain that a little bit more?
Sure. So acceptance, in almost every construction contract, what you'll see is some type of clause in there that says acceptance of or final payment is not approval or acceptance of your work. And that's because things always manifest themselves years down the road, and it's to prevent the contractor from saying, look, I'm off the hook. You accepted it. You paid me in full. Okay. So I think that the real significance of what we would call acceptance is if there's some type of deviation from the plans, right, and it's obvious, and the owner and the architect say, okay, that's fine. We're going to live with that deviation. That is something that would get a contractor off the hook. But a lot of contractors think that, okay, just because they received final payment, that the owner was fine with everything, and that doesn't get them off the hook for the latent defects that arise later down the road. They might accept substitutions of products. They might accept deviations from where a wall is placed. Acceptance would help out a contractor in those situations. But in terms of latent defects for workmanship, acceptance will presumably not provide much help for a contractor or a trade sub.
That's great clarification. Thank you.
And you talked about some of the long tails or long periods of time that can pass for latent defects. Are there any limitations on those periods of time?
There are. So there are, I'd say you have sort of three concepts of time periods. You have certain warranty time periods, and those time periods could be in your contract. And what those really say is, okay, if you give a 1-year warranty on your workmanship, it's going to say, okay, if we the owner notify you within a year, you have to come out and fix it at your own cost, right? So there's a sort of a warranty obligation to come out and fix something. That warranty period does not let the contractor off the hook for defects that arise after that period, because you still have latent defects that may arise after that period. So the time frames, and this is very state specific, but every state has what we call a statute of limitations. And a statute of limitations is the time period where an owner or a claimant can file a lawsuit against a contractor for bad workmanship, or whatever, breach of contract or negligence or breach of warranty, whatever. So in Florida, for example, Florida has a statute, statute 95.113C, and it basically says that you have 4 years from the date of completion, essentially, more or less, that you can be sued. However, that's only for patent defects. That 4 years then gets extended, what we call tolled, which is a formal term for extending, where that 4-year clock doesn't start running until the owner knows or should have known that there's a problem. Meaning, if a roof doesn't start leaking until 3 years down the road, the owner then has 4 years from that third year to assert a claim. So now they've got up to 7 years from the completion of the job. And then there's the third concept that I was going to mention is, okay, well, where does that end? There has to be some definitive period where you can no longer have that 4 years counting, and that's what we call the statute of repose. And in Florida, the statute of repose is 10 years from the completion of the job. So if an owner discovers a construction defect in, say, year 8, and it was a latent defect, they would typically have 4 years to sue from the start of that eighth year. However, they're cut off by the 10-year statute of repose, so they would have to file a lawsuit within those 2 years. So in terms of ongoing exposure, what the real exposure that contractors have is it's not really the 1-year warranty, it's not a 5-year warranty. It's really the statute of repose period that people need to be sort of paying attention to, because that's the real exposure of any given project, which is that's a long time for a lot of people. And some states are shorter, some states are longer, some states are 15, some states are 7. So it's really state specific, but you have the basically 3 periods: your warranty periods, your limitations periods, and your repose periods.
So Joseph, are there jurisdictions that will permit you to limit the statute of limitations in a contract? So like if I'm a contractor, I don't want to have that exposure for a certain length of time. Do I have the right to negotiate for a shorter period?
So that is a state-specific question, and I don't know the answer to that in all the states. I do know that in Florida, for example, Florida does not allow you to do that. You cannot put in your contract that, okay, even though the statute allows me 4 years, I'm going to limit it to 1 year. Okay, so you can't do that in Florida.
So they see it as against public policy, I guess.
That's correct.
Okay.
That's correct. Because I mean, look, that statute is out there to protect basically claimants, to make sure that they have the right to make a claim for things that they didn't know about within the first 10 years, essentially.
Right. So again, that sounds like it's important to get jurisdiction-specific legal advice when somebody's looking at these contracts. And standardized forms are good, but they're not necessarily taking into account jurisdiction-specific requirements, right?
That's right, and you want to look at those periods from both sides. I mean, if you have a claim against someone, you need to make sure that you're timely asserting that claim against someone. At the same time, if there's an exposure to you, you may want to try to drag some things out and sort of lay low and see if that time frame expires. But it's all a state specific inquiry, and some of it depends on when the owner or the claimant should have known that the defect existed. But certainly it's something that you would need to speak to your construction lawyer about.
So you had touched on the interplay between the rights and responsibilities of the parties, and they may have certain warranty obligations, and then statutes of limitations and statutes of repose. So can you agree to a longer warranty than what I guess the law would otherwise have you be liable for?
Yeah. So I think I mentioned earlier, for example, what you see a lot of the times with roofing manufacturers is they give a 20-year no dollar limit warranty. And so what, at least in Florida, while you can't agree to shorten the statute of limitations, you can always agree to extend it. And you see that a lot of the times. Quite frankly, you see it a lot of times in surety contexts where you have a shorter period to sue a surety. And if you're trying to work things out, you'll enter into what we call a tolling agreement. And that basically says, okay, we're going to agree to extend the limitations period so that we don't have a lawsuit here. We're not going to hold it against you, but we're going to extend the statute of limitations so that we can try to work this out. Or if you're pursuing other claims, you want to see how things go with the owner before you have to sue a subcontractor. People agree to extend the statute of limitations all the time. It's a pretty common practice because the claim could work itself out without a lawsuit. So you can always extend the statute of limitations.
Okay. I imagine it's pretty important for there to be a distinction between the contractor's warranties being given and manufacturer warranties from a construction defect perspective. And are there, I imagine it's very important for contractors to differentiate and maybe have a discussion or negotiation with the owner over what they're warranting versus maybe direct warranties given by a manufacturer. Would you say that's true?
Yeah. So, I mean, typically what you would negotiate for if you're a general contractor is that you'll give your limited warranty period on your workmanship, and then you'll agree to basically hand over a manufacturer's warranty where the manufacturer of the roofing system that's ordered directly or issued directly to the owner, where the owner can then call up the manufacturer and say, hey, look, take care of your stuff, and you don't have to involve the general contractor. So when you've got manufacturer warranties, you always want to make sure that the manufacturer is issuing those directly to the owner. But at the end of the day, if there is bad workmanship, the general contractor is still going to have exposure to liability. You just hope that, as a general contractor, you would hope that the manufacturer steps in, honors its warranty obligations, and takes care of a problem that pursuant to the terms of the warranty.
Right. So where do you most often see construction defect litigation arising? I know you had mentioned, I think you used an example of condominiums. Is that an area rife with lawsuits?
It is. It is for a couple different reasons. Florida is really rampant in condo litigation because on a typical construction project, if you're a general contractor and you're building a project for a client that you do repeat business with, if there's a problem down the road and a legitimate problem with the building, that client then calls the general contractor, and the contractor typically wants to make good on their work because they care about the ongoing work. Condos are a little bit different because condos, you turn over ownership of a building from the developer to an independent group, a board of directors. And oftentimes they get approached by consultants that say, hey, look, we'll go take a look at your building and we'll get you a big pot of money that you can put in your reserves and fund this thing. And you've got a board of directors that says, okay, look, it's not going to cost me anything. These lawyers and these consultants are agreeing to do this for free. They've told me they're going to get me millions of dollars by scouring my building. Me as the board, I've got no relationship with the contractors. I don't care. I know that all these contractors have insurance, so it becomes a big insurance grab. So down here in Florida, at least, and I think California is pretty big in condo litigation as well. But you have a board that's really out there to go find as much insurance money as possible, and it all comes under the guise of construction defects. But that's really where you see most of it, because a lot of times if you've got just a normal commercial owner that has an ongoing business relationship with the contractor, they'll try to work things out and fix legitimate issues. They're not just looking to put cash in their pocket. That's what I see in the condo litigation. So certainly, at least down here, I see a lot more litigation over condo defects than any type of other thing. But you also have when you've got litigation between commercial construction parties, you might have a delay claim where a project gets delayed, and it's because they did bad work and they were correcting it, and it impacted the schedule. That's just not as it's not as obvious that it's about a construction defect as it is when you look at a condo litigation of a 10-year-old building.
So in both those instances, could you comment on how important it is for the contractor and trade contractors to have good documentation about their work?
Yeah, sure. So in any type of construction project, documentation is important, because if you have litigation a year down the road, 3 years down the road, 5 years down the road, or 10 years down the road, people don't remember the conversations. People don't remember that the superintendent told you to put this product here, and he told you that, right? People don't remember those conversations. People don't remember that the general contractor told me to do this, or the owner said this was fine, right? People's memories fade. People leave companies. You don't have the same people that were involved in the project years down the road, or companies go out of business. So what are you left with when you've got a claim that comes 10 years down the road? You've got your project file, okay? So it is important that if you're ever asked to deviate from the plans or anything like that, to make sure that it gets documented either on your as-built documents, your daily reports, meeting minutes, anything like that, because at the end of the day, when it's a claim, people's conversations, everyone's got a different recollection of things. So there's always three truths in the lawsuit, right? There's one side of the story, the other side of the story, and then whatever some fact finder believes to be true. But if you've got what we call contemporaneous records where you wrote something was written down to document something at the time, that's probably going to be a more accurate reflection of what happened than someone's recollection 10 years down the road. So it is extremely important to document things in your file or through an email. It doesn't always need to be a formal notice, just something in writing that someone can rely on and sort of put the story back together in an objective manner years down the road when people don't remember any of this stuff.
Yeah, it sounds like documentation is a really important part of mitigating that risk. What are some other ways that you can limit your risks in this area?
Well, so, I mean, as with anything, the managing risk is done in a few different ways. It's through your best practices, through documentation and making sure that you've got good quality people out there doing the right work. You can also insure risks. I mean, that is one way to protect yourself from a construction defect claim. I mean, presumably making sure that you've got enough insurance in the event that there's a claim that, okay, you're paying your premium, which is a known amount of dollars, in exchange for knowing that your insurance company is going to cover X amount of dollars of risk. So that's a way to manage your risk. Another way to manage your risk is through shifting the risk through indemnity, making sure that if you're a general contractor, if I get sued for workmanship, I want to make sure that my subcontractor is going to protect and indemnify me, at least for their own bad work. So that's ways to manage the risk. And then there's different sort of project management techniques about proper documentation, maybe hiring third-party quality control consultants and to make sure that you're doing things per plans. But those are all sort of risk management techniques on how to get the risk off of you onto someone else.
So are there certain points in the contracting process where it's best to work on limiting risk? Is it before construction starts in the contracting phase, or are there times later in the process? What's the best timing for kind of limiting this risk?
So really the best time to limit risk is in your contracts. And people are generally hesitant to try to push back on contracts because if a project goes well, you hopefully never have to refer to your contract. Contracts are there for when things are not going so well, and they're there to protect the parties and protect what the parties believe they're contracting for. So I think the most critical time to protect yourself from a construction defect claim is to anticipate it and making sure that you've got the right indemnity protections, making sure you've got the right insurance requirements, making sure you've got the right what we call additional insured requirements, and then the best practices in terms of when you actually get into the construction project. All of that stuff in terms of proper documentation, that's all stuff that companies want to do anyways, right? So you want to make sure that you got the right people out there, that you're doing your work properly, you're following the plans, you're following the specifications, and just construction best practices is what makes contractors good. But the contract is really where you're best going to protect yourself.
So as we always say, read those contracts and make sure the clauses are in there.
That's right. That's right.
Joseph, I just want to thank you for being on with us today. It was great talking with you about how to mitigate these risks related to construction defect claims. Hopefully we'll have you back on another episode sometime and can chat with you more.
Yeah, thanks so much for having me. I appreciated speaking with you. Look forward to speaking again soon.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Old Republic Surety for their generous support in sponsoring this episode of Let's Get Surety. For more information on Old Republic Surety, visit www.orsurety.com.